Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. As you can see on the screen, I'm Dan Balkaran, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee side employment law firm. Housekeeping notes before we get started. If you want to get a hold of us or me, you can do so at employmentlawyer.ca. help@employmentlawyer.ca, 1-855-821-5900. Okay, let's get started. I understand we have some questions, but I'd like to get to all of them in the next half an hour. So if you could send them in as quickly as possible. That way I can work my way through them. Okay, we're just waiting for the questions to be posted. While I'm waiting for those questions, okay. There they are. Okay. Sorry about that. We're having technical difficulties. Okay. Question from Pam. My employer recently announced that unused vacation days can't be carried over to the next year and would be lost without pay. I understand they can refuse carryovers, but I thought if vacation couldn't be taken due to workload or scheduling issues, they're required to pay it out. I haven't found a clear answer online. Can you clarify this? So I don't deal with vacation pay very much, this type of issue. But my understanding matches yours, which is the vacation pay is an irreducible requirement under the Employment Standards Act if you're provincially regulated, and so they have to pay it out if you don't take it. And so what a lot of firms do, a lot of companies do, is they make you take it. And if you have a bunch of bank time, they don't want to carry it over and pay you a bunch of money. They say you got to take your vacation at the end of the year. So my understanding matches yours. The answer for you would be in the Employment Standards Act and the guidelines on the Employment Standards Act. British Columbia has guidelines on the Employment Standards Act. Each province is different. I imagine your province has something similar, but either Employment Standards Act, code, whatever employment standards legislation, if you're provincially regulated in the province you're in, should provide you the answer. But yes, my understanding, broadly speaking, and again, I don't know much about it, but is exactly as you, which is they can't just take away this irreducible requirement, which is that you get 2 or 3 weeks vacation a year, and if you can't take it, they got to pay you out, or I guess carry it over with your consent. Question from Amir. Hold on a second. I got a few more questions. I've been working 50 hours a week in a salaried role and recently learned that I may be misclassified as management to avoid overtime pay. I don't supervise anyone or make high-level decisions. If I've been misclassified, can I claim unpaid overtime retroactively? Yeah, you probably could. I don't know. The manager definition in the Employment Standards Act, again, if you're provincially regulated, I mean, I'm referring to BC here, but they're all fairly similar. They're not. It's not necessarily stringent, but if you're clearly not a manager, sorry, let me rephrase that. It's stringent against employers. You can't just broaden the concept of manager to avoid paying overtime for extra hours. But Amir, I think you have a broader question, which is, do you like where you're working? Can you see yourself growing there, moving up vertically in the organization? Everyone wants to, in an organization, if you can move up positions, that moves you up on your resume, so that when you move laterally or move between companies, you're higher up on the or at least you can move into a higher position at higher levels of pay. And so if that's an opportunity there for you, I'll tell you, if you come to them and say that, which is, you weren't paying me for every minute I was working, even though I was a salaried employee, I certainly don't think any vertical movement will be open to you there. And you may find that the relationship sours quite substantially to the point that you won't eventually be working there. So, notwithstanding, if you mention that and they fire you, at least in BC, you'd have an employment standards branch claim to potentially a substantial compensation under the make whole remedy under the employment standards legislation in BC. So, that's also an option that could be open to you. But just really think about the ground floor question of how much money are we talking about here? I mean, are we talking about tens of thousands of dollars? Or are we talking about $3,000? And you weigh that on the scale against, well, do I see myself here for a long time? I mean, businesses want to extract productivity out of employees over and above what they're paying the employees, generally speaking. And so squeezing extra time out of them here or there, is an age-old tradition, and there are protections under the Employment Standards Act for employees. But, if you want to move up vertically, sometimes you have to do extra work. So you've got to balance all that out and come up with the best life decision for you. I hope that helped. Okay, question from Beth. My employer deducted money from my paycheck to cover a customer refund, saying it was my error. I never authorized this, and it wasn't mentioned in my contract. Are they allowed to do this under labor laws? I mean, well, first of all, you said labor, so I don't know if you're a member of a union or not. If you are, go talk to your union rep immediately. Again, I know very little about this. My understanding from the regulations of the BC Employment Standards Act is they cannot do that unless it's in your contract. And even then, I don't think they can necessarily do that for business costs. So the employer cannot, it's been a long time since I've looked at it, but the employer cannot deduct from your check business costs. It could deduct things like you use too much vacation pay, and if we're terminating you or something, then we're going to reduce your severance pay by that amount. It can do that. Or if there was educational money, I think, where they pay for some of your education, but then you didn't stay long enough, they might be able to claw some of that back. But this, no, I don't think they can do that. But it goes back to the Amir question. Are we talking about $35 or are we talking about $10,000? And is this worth it to make a fuss over? And I know that's unfortunate because, or it's not what you want to hear because this is wrong. Right. But if you were to go through official channels to deal with this, such as the employment standards remedies that you might have, you probably, would it be worth it, right? To file an employment standards branch complaints. I can't remember how much it is, but maybe it's free. It might be free. Sorry, I apologize for that. But if you do get your small sum of money back, by initiating proceedings like that against the employer, they're eventually going to want to get rid of you. You'll be protected from that for a period of time, because if they terminate you in reprisal, I don't know about every province, but certainly in BC, you'd have a pretty substantial remedy. But nonetheless, I'm sure that would sour the relationship substantially. If this is a real important issue to you, and again, if it's $35, I wouldn't worry about it. But or at least that's what I wouldn't do. You might, but if it's a real big issue to you, talk to them and see if you can get some sort of amicable resolution. Because I've never heard of that. But is it illegal to do that? My understanding is yes. But again, it's been a long time since I've looked at the regulations. Your answer will be in the employment standards legislation in your province, by the way. Question from Gnarly. I was recently terminated without cause. My employment contract has a non-solicitation section which stipulates former employees must wait 12 months before working in the industry for clients of the company. Is this still in effect given the circumstances of my termination? For context, the company is struggling and had to do a couple rounds of layoffs. Okay, so I think you might be confusing non-solicitation agreements or clauses with non-compete clauses. So I'm just going to broadly explain what they are and the differences. Okay, so non-compete clauses say that for a period of time, you're not permitted to work for an employer that is broadly, definedly competitive with the employer that you just left, that you lost your job from. Okay, so you make widgets for ABC company, you can't go make widgets for DEF company. Okay, non-solicitation clauses are, broadly speaking, for a defined period of time. You can't poach clients of your former employer, and you can't poach employees of your former employer. So you work for ABC company making widgets, you leave and go to DEF company to make widgets, but you can't steal ABC company's clients or employees to come work or be customers of DEF company for a period of time, in this case, 12 months. They're broadly different. They do different things. Non-compete clause, I don't want to use such strong language, but it's presumptively unenforceable, more or less. Okay, so the reason why is for public policy reasons. If you've made widgets for 20 years, all you know how to do is make widgets, you have a mortgage and 2 kids to support, and now because that employer terminated your employment, you can't go make widgets for another company, and now you can't feed your kids or pay for your mortgage. That's not good for society. It's very bad. And so generally speaking, the courts are not going to enforce non-compete clauses except in strictly limited circumstances. Very narrowly geographically defined. So North America too big, the city of Burnaby in British Columbia might be okay, but it also has to be temporally limited, something reasonable, 6 months, something like that. And then usually it has to be for someone of significance in an organization. So someone like a vice president might have trade secrets and insider knowledge about the business. Widget maker does not. And so, again, not in society's interest to punish widget maker, whereas there's a legitimate business interest to have a non-compete apply to the vice president. So generally speaking, I haven't seen your non-compete, but probably not enforceable. Generally, I'm not going to say for sure. Non-solicitation clauses, though, and this is why I had to explain the difference, because I think you're confusing the two. But non-solicitation clauses are presumptively enforceable. The courts have been consistently fine with, you can't steal someone else's clients or your former employer's clients, and you can't steal their employees for a period of time. That's doesn't infringe on an employee's ability to feed his family and pay his mortgage, et cetera. And so because of that, there's no sort of public policy curb on non-solicitation clauses in the same way. They'd still have to be properly defined and everything, but and all the legal T's and I's, but they're broadly enforceable. So if you're asking about, can you poach or steal former employees for 12 months? No. Is it going to be enforceable? Yes. If it's a non-compete clause, you're probably okay, particularly given if the company is in financial trouble. Now, it doesn't mean that they're not going to troll for money by, threatening to sue the new employer and you, but they're going to have a hard time with that because they're going to have to prove loss, most likely. So I hope that helps and answers your question, Gnarly. So just trying to see if I got the whole thing. I think I did. Let me know if I come back in if I didn't. Question from Turner. I hold a security clearance for my job that's about to expire, but my renewal paperwork was delayed because legal told me not to submit it yet. I have emails showing I followed their instructions and followed up regularly with no response. Now they're saying I have to go on unpaid leave once the clearance expires. I'm not in a union. What are my rights in this situation? Ooh, that is a very tough question. So on the one hand, they can't just put you on unpaid leave and it's a constructive dismissal and you could claim severance. And maybe you don't want that, but maybe you have 20 months coming to you. I don't know. Depends on what your contract says and your age, length of service, and position, generally speaking. On the other hand, you can't do your job without the security clearance. And that technically might be a frustration of contract, although it's temporary, so you could argue against it. And a frustration of contract is where, through no fault of either party, and I know there's fault here, but through no fault of either party, you're unable to perform your job, the core components of your job on a permanent basis. How can you do that, when you don't have your security clearance? And so they can't let you do that. They can't let you work, but they want you to be there. I think you might have an interesting constructive dismissal claim if you've got emails from legal saying don't submit it because you just followed their instructions and now you're supposed to eat it in terms of not getting paid. I think the real question for you, Turner, is how long is it going to take for your security clearance to come in? Is it going to be a month? If it's going to be a month, maybe negotiate with your employer and say, look, you did this. This is on you, not me. Pay me can I take my vacation pay, or pay me for the month, or let's split it 50-50 and then I'll go on a holiday. If you want to work there, like if this is a good job, then figure something out with your employer. However, if this is 8 months, I think you need to talk to an employment lawyer. If it's 8 months, you should really kick the tires on this one about whether or not you've got a constructive dismissal and if it's worth it in the circumstances. But it's tough. That is a tough little fact pattern there, because how can you do your job, right? So the employer can't let you do your job, but on the other hand, they just stopped paying you because you followed their instructions. So it's a really interesting one. I think that's the kind of case that lawyers talk about for a long period of time at all the conferences, when a decision comes out, because of the interesting facts and the conflict between the two of the broad principles in play. But I would, Turner, if it's not just a short period of time, that you're going to be without work, and you want to be at this job, I would talk to an employment lawyer right away. If you want to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. If you're in BC, feel free to reach out to me. That's a fascinating one. If the moderator can put my contact on the screen, there's my contact. Feel free to reach out to me if you want. Happy to talk to you about that one. But if you're not in BC, certainly talk to an employment lawyer in your area. You can get a hold of us if you want. We're in Ontario, Alberta, and British Columbia. So, but again, if it's short, it's a month, just 2 weeks, 3 weeks, 5 weeks, just figure it out, see if you guys can split the difference on the pay or something like that, and then go on a holiday. And I know that's tough, but maybe it's a good job that you like being at. So, I hope that helps, Turner. But it's a complicated situation. Okay, James asks, can my employer cut my hours without asking me for my consent first? That is a big question. Okay, how much time do we have? Okay. So, James, what you're talking about it's not a great area of the law for employees. So, your employer can do whatever it wants. The question is, do you have a legal remedy if it does that, right? And so in this case, if it unilaterally imposes on you a pay cut or an hours cut that you do not accept, or more specifically, that you reject, then you've actually been constructively dismissed, okay? So a constructive dismissal, a constructive termination of your employment is where, it's where your employer, just to get technical, repudiates your contract of employment. But specifically in your situation, if you're working at 40 hours a week and it says, hey, James, now you're working 20 hours a week, and it's not just a blip for 1 week, it's, you don't know, but it's probably indefinite, or they've said this is a permanent change. Well, that's not the circumstances, the contract of employment that you were working under before. And so, now you went from making $100,000 a year to now you're making 50. Who would stay in that situation? The answer is the employer has effectively terminated your employment, but only if you trigger it by rejecting their unilateral change. This is very important. If you agree to their change, you're done. That you've accepted it. I mean, this is a little more complicated than that. There's some cases that go either way, but it's very, value of your case is cut in half. So you've accepted it at that point, and so you don't want to do that. What you want to do is preserve your strategic options. If they cut your pay, talk to a lawyer. Don't talk to them, just talk to a lawyer and find out if it's a constructive dismissal. Now, why I say if, there's a case in BC, and it's not always followed, but generally speaking, and this is sort of more or less the situation across Canada, if an employer cuts your hours or pay, well, they're basically the same, but by 20% or more, it's automatically a constructive dismissal. If it's below 10%, it's not. I don't know why, but it's not. I mean, I guess because it's considered trivial and you should just bear it, but I don't like that at all. But that's the law, or more or less the law. If it's between 10 and 20%, it could be a constructive dismissal if there's more. So if they took something else away from you, or they demoted you at the same time, changed your title, took away some benefits, etc. So it could also be. It just goes to that idea that the employer has repudiated your employment or your contract of employment. And so let's just say in your situation, it's 20% or more. And it's not a slam dunk, by the way. It's something that's fought over. But let's just say they cut your hours by 50%. You come to me and we pursue a constructive dismissal claim. What will happen in that situation is I will send a letter on your behalf, or let me rephrase that. A lawyer on your behalf, let's just take me out of it, will send a letter on your behalf, most likely saying James rejects this demotion and considers it a constructive termination of his employment. Or not demotion, sorry, hours cut. What happens is your employment is terminated right there, okay? You terminated your own employment. You now have no job, you have no job and no money, okay, coming in. And you then have a wrongful dismissal claim for severance because they didn't pay you any severance because you triggered your termination. Okay. Why this? You might consider doing this, aside from the fact, and many employees come to me in situations like that and say, "I can't work here anymore. I'm going to quit," and instead they pursue a constructive dismissal, and that might be where you're at, where you're just emotionally done with what they did. Okay, but generally speaking, if you have 5 weeks of pay coming to you, if you trigger your termination, it's not necessarily worth it to do that. You got 12 months coming to you, that's a different story. So you want to talk to a lawyer and evaluate what your severance entitlement is and see if that makes sense for you to pursue a constructive dismissal in that situation. So 2 things very important. Well, it's really 1 thing. Do not do anything that may consent or approve of the employer's change to your hours, or reject it until you talk to a lawyer. And even after you talk to a lawyer, you shouldn't run. If you decide to reject it and pursue a constructive dismissal, no employee should do that on their own. You should do it with the benefit of ongoing advice from a lawyer. They're too hard, they're too complicated, and too many things can go wrong. If you claim a constructive dismissal and you're wrong, you know what happened? You quit. And if you go to court and the court says you quit, you get nothing. Actually, you'd owe money. So you gotta be very careful with these. Notwithstanding, you very much may have a constructive dismissal, and you should talk to an employment lawyer right away. So again, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Sorry, James, if this is a big hours cut. If this is 4 hours, it's probably not going to do it. But if it's a big hours cut, you should definitely talk to an employment lawyer and find out if you've got something there. Okay. Brittany says, my employer has issued an RTO for all staff. Sorry, I don't know what an RTO is. When I signed on with the company, my contract says that it's a flexible work environment. Is this a return to work? Is this change? Return to office. Thank you, moderator. Is this change a violation of my contract agreement? Depends what your contract says and the terms under which you were hired. This is a new post-pandemic situation. So if you worked there before the pandemic, you worked in the office, and then and then you went to work at home during the pandemic and you just sort of stayed at home, you got no case. The employer is going to call you back in and you've got to go because you have no freestanding right to work at home. What you have to do is you have to adhere to the reasonable directions of your employer that are reasonably congruent with the four corners of what your job is, okay, more or less. So whenever I say that to someone, just to explain it, like if you're in customer service and your employer says, well, now I want you to take calls from this client, and you say no, that's insubordination and it's just cause termination. Okay, I mean not once, but if you do it over and over again. But if it's outside of the scope, like the employer asks you to go clean the toilets in the bathroom when your job is customer service agent, that's probably not going to be within the four corners of your job. And so the question is, in your case, did you sign on or when you signed on, was it an agreement that you would be able to work at home? Is that part of it? Right. So look at the contract. Were you hired after the pandemic or in the middle of the pandemic? And what was the expectation? If there's no contract, yeah, you might have something. Reasonable expectation of the parties were that you could work from home, in which case forcing you to come back is a constructive dismissal. And again, I'm not talking about if you're a unionized employee. If you're a unionized employee, you need to talk to your union rep. But if you were hired, if you've been working there since before the pandemic, no, you got to go home. You got to go back to work. If it's after, what does your contract say? If it's silent on it, I think it's an arguable question. If your understanding was, it's tough because your contract might say this is the entire agreement. But if it's silent on it, yeah, you got something there. But the question is it worth anything? Because you got to claim constructive dismissal, right? So again, it goes to the same question that James had. By forcing you back to work, is your employer repudiating your contract of employment? A better way to say that is, was working from home an essential term of your employment? It might be. You might have moved, 2 hours away because that's what you thought. And so more and more of these cases are working their way through. Broadly speaking, no freestanding right to work from home unless working from home was an essential term of your employment. And so, yeah, you might have something there, but it's got to be worth it for you because you got to pay for the lawyers involved and all that stuff. So, okay, we've only got, hold on, let me just, moderator, let me see if I can't race through all these. I'll try to get a couple more done and then I think we'll have to cut it there. I'm sorry. BB asks, I had a follow-up meeting with HR manager after getting back-to-back letter of expectations. I asked for mutual separation agreement. Am I wrong? Technically, you might have just quit. So see what they do. Maybe they'll package you out since nobody wants you to be there, or since you don't want to be there anymore and they don't want you there. But, if you said, hey, I want to be let go, you might have technically quit. I think that's a tough one. You may want to reiterate that you're not quitting before they treat it as a resignation. But, negotiate with them and see if they'll do it. But they have no obligation to do so. Neil asks, my boss asked me to take an unpaid leave time. Business is slow right now, and he wants me to wait and see if things pick up. What happens if I agree? What if I disagree? Not sure what to do. You may want to claim a constructive dismissal. It's the theme of today. Talk to an employment lawyer right away. It's different if he put you on layoff. He should have put you on layoff. He didn't. But have your hours been interrupted? If you just say no, what's going to happen? Or has he already done it? So talk to an employment lawyer. Moderator will put her contact information on the screen, but you might have something there depending on if the employer has done anything. Thor asks, I have recordings and emails to back up all of my claims and their refusal to accommodate. I have no idea what you're talking about, Thor. There we go. Question. I'm salary. This is the last two questions. I am salary, was on short-term disability, went to come back, and they offered me performance improvement plan, fired for cause in 4 weeks, or take MSP, a minuscule amount. When I asked for the PIP with my disability accommodations, they forced me to, I don't know what EDB is. I went to HRTO. Should I have gone the civil route? Thor, you need to talk to an employment lawyer. That's too complicated. You may need an employment lawyer. We'll have the moderation on the screen. Contact one of our lawyers and see if you've got something there. But generally speaking, if you're on disability and then your employer says you're fired, you've got a human rights complaint, and you may also have a wrongful dismissal claim. So I would definitely kick the tires on that one with a lawyer, Thor. I don't know, you've already gone some way through human rights, but you might need a lawyer for this one. That sounds complicated. Last one, Aaron says, how you draft a termination clause that survives provincial employment standards invalidation, avoids constructive dismissal, and still forces arbitration that won't be struck as unconscionable. How do you? I mean, drafting termination clauses is an art. So it's not a science, and it's different from province to province. So what you should do is you should talk to an employment lawyer who can assist you in drafting such clauses in a way that gives you the best chance of avoiding the things that you talked about there. Okay, that's it. We got through all the questions. Thank you. They were great questions. Appreciate them all. If you want to contact us, Monday, join us on Monday, September 29th, 1:30 p.m. with Chris Justice. That'll be a great show, so come join us then. I'll be back in my usual time slot in 2 weeks, 10:30 a.m. Pacific time. If you need to contact us, that's me on the screen, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Thank you all for the great questions. Have a wonderful and safe weekend, and I'll see you here in 2 weeks.